Tonight, removed Asin North MP James Gyakye-Quayson breaks silence, giving the clearest indication yet he will contest the by-election in his constituency, which is some 26 days away. We'll put a spotlight on this development and expand the conversation to deal with the broader issue of the political rights of dual citizens with lawyer, activist, and public intellectual extraordinaire Professor Gyakye-Quayson. Prof, you're welcome to UPfront.
Good to see you again.
Wonderful to know, but it's a situation that's developing. The man you barely 5 hours ago had clearly indicated is in the position, it's not bad, from contesting the election, has really told everybody in the country today in a 5-page document that he is in the race, a seat he just lost not long ago, that he will contest and hopefully retain that particular seat. There are questions that are being raised about the propriety of that particular decision. We will come to that. But another issue you've been particularly passionate about and following is that of the former Auditor General, Daniel Domilevo, whose very call from the leadership of this country, straight from the office of the president, for him to proceed on leave, has been declared unconstitutional by the Supreme Court. Let me first start by picking your brain on that, if you may.
Well, you will recall that I actually had filed a lawsuit wanting the court to declare that action by the president unconstitutional sometime when it happened in 2020. And when Domilevo retired, 167 days after I had filed that lawsuit, I decided to withdraw the lawsuit because I thought the Supreme Court had constructively sided with the president by failing to act in a timely fashion. Nevertheless, better late than never, and I completely agree with the Supreme Court. It was very, very, very clear that the president had no power to ask an independent constitutional officer, such as the Auditor General, but you could extend it to the Chief Justice or a member of the Supreme Court or a member of the Electoral Commission, any of the independent constitutional bodies. These people are independent for a reason. And in the case of the Auditor General, he also audits the president. So it is bizarre for the person who is audited to ask the person who audits him go on leave. So I'm glad the Supreme Court has done the right thing here.
Now, of course, you had said that you withdrew your case, mindful of what you construe to be some constructive support for the decision of the executive. There are some that are still looking at that matter from in hindsight and saying, well, it's obviously a clear-cut case of justice delayed, justice denied. Do you agree?
Yeah, absolutely. I agree. And that was the reason why I withdrew my lawsuit, because I felt that at that point, any decision that they would make will merely be stylistic. Nevertheless, it's a decision that is good. It will go to our case law. Students will read about it. Future presidents will know that they have no power to ask independent constitutional officers to go on leave. So yes, there's some value to the decision. It's clearly delayed, but it's still better than never. And we should accept the small victory here, and we should commend the Supreme Court for doing that as well.
Now, there is a related question, though, and some have already said, so there are no repercussions for the conduct of the presidency on this one, apart from the public shaming that this judgment might deliver to them and the estoppel nature of it, preventing people in that particular office from acting in such a manner in the future. Some say for a man who took an oath to do right by all manner of persons in the country, there should somehow be some repercussions for some of these decisions. Possible?
Well, you know, President does a lot of things. As long as the violation of the Constitution is not willful, I don't see how he himself could be held personally accountable for something like that. Nevertheless, there needs to be a better way of making decisions at the presidency. Because to me, this was not a very close decision. It was very, very, very clear from day one that the president had no power to do this. And there was a standard argument on TV. There was one where I appeared on Joy with the Attorney General. And when you heard the arguments that they were making, the arguments were very, very, very porous. And I was actually surprised that they were making those types of arguments. In WAEC, West Africa Exams Council versus Awuni, the students who were unconstitutionally denied the right to take their exams were awarded 5 million cedis each. If the Supreme Court had so wished, they could have awarded some compensation to the Auditor General. The ruling is not out, so I don't know whether such action was taken by the Supreme Court. But clearly, there has to be some system of holding public officers, even if not their person, some way of getting their offices to pay compensation to people whose rights they abuse. Otherwise, there is no incentive to do the right thing.
The crux of this conversation tonight is to critically look at the dual citizenship issue in the Republic of Ghana. But a more recent issue is really bringing it to the fore in a big way. That is the status of James Gyakye-Quayson as Member of Parliament for Asin North. In fact, earlier today, not long ago, he had indicated that no matter what happens, he will contest the election. I did see you post quite an extensive support to the school of thought that says nothing bars him from contesting the election. Please put it in proper perspective for us.
Well, the law is very clear as to who can run for an MP position. First, there are some eligibility requirements. The eligibility requirements are quite straightforward. You have to be a Ghanaian, you have to be a certain age, you have to be a registered voter, you have to be a resident in the constituency, and he meets all that. Second, there's another bucket of eligibility requirement that relates to whether you are a police officer, whether you work for the Electoral Commission, and so on. None of those things apply here. And then third, there are some disqualification criteria. So even though you are eligible, you could be disqualified if any of those things occur. So for instance, if you are a criminal lunatic, if you are a convicted felon, if you are a bankrupt, if you have been convicted of evading taxes, or if you owe allegiance to a country other than Ghana, then you'll be disqualified, notwithstanding that you are eligible to run for office. In this case, he is not disqualified on any of the grounds that I've enumerated. And so, yes, clearly he qualifies to run for the by-election.
Now, of course, he has indicated he's going to do so. But part of his defense is really to say that I still disagree with the court in the decision that they made on my status and on my very case. And that, to me, that was not the very best of decisions to make. You probably, like you have indicated in times past, I've always had a difficulty with how the entire Gyakye-Quayson matter was dealt with right from the beginning, isn't it?
Yes, not just Gyakye-Quayson, but also Adamu Sankedi, and not just those two people in parliament, but also people in the executive, like my good friend Akwasi Prempeh in 2008, 2006, like Monacote, like Adubuahin, and so on and so forth. We need to read the Constitution carefully. If you read the Constitution carefully and you look at Article 8.2, Article 8.2 specifically says a person who is a citizen of a country other than Ghana cannot hold the position of ambassador, secretary to the cabinet, chief of defense staff, IGP, commissioner of customs, director of immigration, and any office specified by an act of parliament. So that is a targeted article, and that is directed at dual citizens. If you see another clause talking about something other than citizenship, it is the most naive form of interpretation to then interpret that article that is using a different language as saying the same thing as Article 8.2. So when you go to Article 94.2a, Article 94.2a says, a person who owes allegiance to a country other than Ghana. You have to ask yourself, if you are serious, well, why is it that Article 94.2a is talking about owing allegiance to a country other than Ghana, and Article 8.2 is talking about citizenship of a country other than Ghana? It is, to me, judicially irresponsible, if not reckless, to just say that, well, the two things mean the same thing. That means you are basically rewriting the Constitution. The people who wrote the Constitution have specifically indicated that they want these two things to mean something different. And so you have to search for what it means when they say owe allegiance to a country other than Ghana, than to just say, well, we think allegiance to a country other than Ghana means citizenship, so we are going to put citizenship in Article 94.2a. It would be the same thing as saying, when the president takes the oath of allegiance, because we see allegiance there, we have to conclude that the president is taking an oath of citizenship. No, the president, when he takes an oath of allegiance, is taking an oath related to his job. And likewise, Article 94.2a, when you do a little bit of legislative research, legislative history, if you go to 1968, this is the genesis of this Article 94.2a, they tell us that Article 94.2a is occupation related. It is targeted at Ghanaians, mono citizens who work in the military, as an example, in the military of a foreign country, or mono citizens who act as spies for other countries, or mono citizens who perform functions that are incompatible with their position as MPs for other countries. That is why we have Article 94.2a. In fact, even a casual reading of the Constitution, you go to 1992, dual citizenship was even outlawed. There was no such thing as dual citizenship, because if you were a Ghanaian and you acquired the citizenship of another country, you automatically lost your citizenship. So you have to somehow be saying that Article 94.2a was directed at dual citizenship, even though the Constitution itself did not allow for dual citizenship. I cannot understand how a serious court, evaluating such an important clause that affects 3 million people, can just ignore just the syntactic arrangement of the Constitution and conclude that somehow Article 8.2 and Article 94.2a are saying the same thing. And anytime they see allegiance to a country other than Ghana, they are going to replace it with citizenship of a country other than Ghana.
Prof,
so,
if I may, I mean, judges do not come to conclusions or determinations willy-nilly. The presumption is that they would have done some better review, sometimes based on precedents, or also a very proper theoretical understanding of the area here. At what point in time did we get to misconstrue, in your own understanding, this citizenship requirement as also being coterminous with allegiance?
I think we misunderstood it in 1996, because remember, in 1996 was when we allowed dual citizenship, when Act 527 was enacted. Mm-hmm. Before Act 527 was enacted, nobody even talked about Article 94.2a, because, I mean, allegiance to a country other than Ghana is an extreme form of violation. Somebody who does that is not only barred from going to parliament, he can't work on the executive, he can't work in a political party, he can't work in any of the constitutional bodies, he can't work in any of the commissions that we have in the country. So the people who thought about it left it for very extreme violations. And when we enacted Act 527 and allowed for dual citizenship, certainly this dormant clause, which has been in our constitution, quite frankly, from 1957, 1969, 1979, 1992, became to be evoked against dual citizens, even though it was never meant to be applied to them. And the only article in the Constitution that directly deals with dual citizens is Article A2, which basically says a person who is a citizen of a country other than Ghana cannot be, and then it specified 3 or 4 or 5 offices. So it was at that time, in 1996, that the misunderstanding occurred, but it was first applied in 2006 to disqualify Akwasi Agyeman when President Kufuor nominated him as the Deputy Ashanti Regional Minister. And then it continued with Adamu Sankedi when Article 94.2a was applied, even though they were all talking about dual citizenship. And if you go back, I've written maybe over 50 articles on that. And then it was applied to Monacote in 2014, then to Adu Boahen, and now Gyakye-Quayson and the MP from Jomoro. And so that is when the misunderstanding occurred in 1996, when the law was changed to allow for dual citizenship.
And I was talking about how judicial decisions are arrived at and the kind of scrutiny and the prudence mostly expected. How come that the various levels of our courts have not seen through this and have allowed this to fester, evolve into a matter that is concurrently coming up for review basically every time there's a new government, or every other 8 years that we are talking about a government coming into play and new people being appointed in the country? How come people have not seen it from your perspective all through?
It's hard for me to explain. It's hard for me to understand because, look, let's just apply common sense. If in 1992, dual citizenship was not allowed, how can an article in the Constitution be referring to dual citizenship? I mean, if you have never been to law school, just use your common sense. 1992, we have a constitution. The constitution says dual citizens cannot be, if you are a Ghanaian and you are a dual citizen, you are going to lose your Ghanaian citizenship. Okay? Then we have another thing which says if you owe allegiance to a country other than Ghana, you cannot be an MP. How can any reasonable person say that line applies to something that is not even allowed? It's just that I think people are just being very, what is the word? Mechanical. They see allegiance to a country other than Ghana, and they say, oops, there's a country other than Ghana, therefore allegiance means citizenship. Allegiance could mean a whole lot of things. Allegiance surely means citizenship, but it also means it can be occupation related. Allegiance can also be somebody who is just a permanent resident. Any foreigner in Ghana owes allegiance to the country because they have to obey our laws. Any foreigner in any country, in the common law, we call them the denizens. The denizens owe what we call local allegiance to the government, to the sovereignty. Then there's allegiance that you owe as a result of your job. So for instance, in the state of Maryland, in the US, if you want to be an attorney, you have to swear an oath of an allegiance to the state. In California, if you do any state job, you have to swear an oath of allegiance to California. So allegiance can be used in many contexts, and we have to ask, in what context was it being used in the Constitution in 1969? And you simply have to go to the memorandum from the Constituent Assembly of 1969 and look at paragraph 415, paragraph 416, and paragraph 417. They state it explicitly. You don't have to believe me, just go and look at it. They state it that the allegiance here is occupation related. It refers to people who have taken jobs in foreign countries that are incompatible with their position as MPs. It has nothing to do with citizenship because in 1969, we didn't allow dual citizenship. In 1979, we didn't allow dual citizenship. In 1992, we didn't allow dual citizenship. So they had a reason, they had a meaning for it. And we have just bungled it. But quite apart from that, let's say we even somehow misinterpret it to mean citizenship. The way then it has been applied in the Gyakye-Quayson case is completely wrong. Because you also have to then read the statute. Because you see, Article 94.2, if you read it, it says a person who owes allegiance to a country other than Ghana is not qualified to be an MP. Fine. When is that determination made? The Constitution does not tell us, and we find answers to that in the Enabling Act or in the statute. So you go to PNDC Law 284. And PNDC Law 284 in Section 9(1) and 2 clearly makes a distinction between eligibility and disqualification. In Section 9(1), it says a candidate who applies to be an MP has to meet the age, has to meet the citizenship, has to meet the residence requirement at the time that they file their nomination. It states that explicitly. Then when it goes to 94.2, it departs from that candidate language and it says a person is disqualified from being an MP, not when he's a candidate, but when he goes to swear oath, when he tries to enter parliament. At the time that you are entering parliament, do you owe allegiance to a country other than Ghana? Whatever that means. That is why the Electoral Commission, who is the regulator in this instance, examined the renunciation certificate of Gyakye-Quayson before the election and certified that he is competent and qualified to run. He did not run on his own accord. He gave his papers. He had applied for renunciation of his citizenship as far back as December 2019. And once you apply to renounce your citizenship, the other country cannot prevent you from, cannot say, no, we want you to be our citizen and we are not going to allow you to renounce your citizenship. So when you apply to be a citizen, the call is made by the country that you are applying to. But when you say you no longer want to be their citizen, they have no option but to let you go because they cannot force you to be their citizen. And what we are saying here, or what the court appears to be saying here, is that they are going to allow a foreign bureaucrat in Canada to determine whether or not you owe allegiance and when you have renounced the allegiance. The other important thing is whether you owe allegiance to a country other than Ghana is not a matter of Ghana law. It is a matter of the law of the other country. They learned this lesson in the Jomoro. You know, in Jomoro, they had the same situation. But they brought a lawyer from Ivory Coast. And the lawyer testified that in Ivory Coast, look, when you become the citizen of another country, you automatically lose your Ivorian citizenship. And that was the end of it, because they found out that they did not even understand the law in Canada. I'm sorry, the law in Ivory Coast.
Mr. Quayson, in his statement, says he renounced his Canadian citizenship in December 2019 and returned to Ghana to serve his people in Asin North when he declared on his nomination forms in October 2020 that he owed no allegiance to any other country other than Ghana. That was to him, in his appreciation and understanding of it, indeed the truth. That's what he puts there. And I stress the appreciation and understanding of it. To date, he claims no one has provided any evidence that I owed allegiance to Canada at the time I filed my nominations and when I was elected and sworn in as the Member of Parliament.
Absolutely correct, because there's a Canadian case, Macarthur. And if you read Macarthur, they tell you that citizenship and allegiance are totally different things. And if you don't want to owe allegiance to Canada, that's up to you. You can just disavow your allegiance any day. They don't care about that. All they care is at the time that you become naturalized, you take the oath of allegiance, and once you've taken the oath of allegiance and you get your citizenship, you can then go immediately outside and say, I've renounced my allegiance to Canada. That's fine. To them, allegiance is something subjective that just demonstrates your commitment to their system of government. But it is a free country, so you are not obliged to like their system of government. You have free speech and you can say anything that you want about their government. So they decouple allegiance from citizenship. There's a website called disavowal.ca. If anyone can go there. And if you go there, people just go and they type, today I've renounced my allegiance to Canada. And the Canadian government has no problem with that because they understand that citizenship and allegiance are two different things. Allegiance is what I myself control as a human being. If I say I don't owe allegiance to you, what are you going to do? Compel me to owe allegiance to you? I don't even understand that logic. Assuming we want to be simplistic and think that allegiance is just citizenship. I mean, even in Ghana, let's be realistic about Ghana. What does it mean to say we owe allegiance to Ghana? I mean, can you be sent to jail for doing something that, I mean, is contrary to your owing allegiance to Ghana? Allegiance and subjecthood are colonial words. They derive from feudal law. When British was trying to conceptualize what to do with all its subjects around the world. And they coined this term, all these subjects around the world owe allegiance to the king or to the queen. Why? So that in times of war, they can conscript them. That is it. That is the whole purpose of allegiance. In Britain, allegiance is not used to disqualify anybody. In fact, a Ghanaian who is not a citizen of UK, if he is permanent resident of the United Kingdom, can run for parliament in the UK. It is only in Ghana that we have allowed this allegiance to be, is to be almost like a chain around our necks, and it's stopping us from breathing.
There's a question raised in part of the conversation, the role of the Electoral Commission in this conversation too. Mr. Quayson appears to think that he did nothing wrong in going by the decision of the EC, that he was duly qualified to contest the election. And has the EC been prosecuted for his determination that I did not owe allegiance to a country other than Ghana? He seeks solace in what he considers to be the decision of the Electoral Commission. Is that really a serious point?
Of course, it's a serious point, because that's what I'm saying. The EC is the regulator of the elections. They monitor and evaluate and so on the election laws. And they have said that to be disqualified on allegiance grounds, the test is not when you file your nominations. The test is when you are going to parliament. So as long as you are able to show to us before you go to parliament that you have renounced your allegiance, whatever that allegiance might be, we are going to let you run. That's why when the EC looked at his certificate in November, the EC said, okay, you satisfy the requirement and you can run. Now, what the court is saying, contrary to what the court normally says about the EC, because the court normally assumes that whatever the EC is doing is regular. We call that the presumption of regularity. Contrary to the presumption of regularity, the court is saying here the EC was wrong in interpreting PNDC Law 284 the way it is written. And PNDC Law 284 is unconstitutional, but not just unconstitutional now that they are saying it, but they are going to retrospectively apply it to overrule what the EC did and to disqualify Quayson. That is some extreme action that the court should not be taking, especially because when it comes to matters of election, they are actually reserved for the High Court. And you cannot have a dispute, an electoral dispute disguised as a constitutional matter, and then use that to rewrite the election law to insert the court-owned timelines into the statute. That is judicial tyranny, I'm afraid to say. We shouldn't allow that.
If I can ask you a question, because this came up, this matter you had referenced about the courts and which court can really deal with this matter. I saw a statement from the General Secretary of the NDC, which said, and I'm quoting parts of it, said, in the light of my previous decisions that we are aware of, many previous decisions that we are aware of, including decisions involving cases of Honorable J.H. Mensah, Baba Jamal, and Peter Amewu, that states that the Supreme Court does not have the jurisdiction to invalidate a parliamentary election, and that the High Court is where such a matter should be taken. It seems strange to us that the Supreme Court gave this particular decision. I hear you saying that even the issue to do with jurisdiction was a problem.
Yes, because you see, let's be honest with ourselves. This started as a High Court matter.
Yeah.
So, and then
and
somehow,
it was settled there. It was
somehow,
settled there.
Yeah, somehow they were having difficulties enforcing the High Court judgment.
Yeah.
And then they ran to the Supreme Court, and then they reframed their dispute in the form of a constitutional matter. And they said, Supreme Court, come and interpret Article 94.2. And then the Supreme Court obliged and then interpreted Article 94.2. And in doing so, inserted some timelines into when eligibility and when qualification should be established. That is not the job of the Supreme Court. That point that they are making is a very valid one. But let us also be sure that we frame the issue in the proper perspective.
Okay.
As long as the Supreme Court gets involved, then it's no longer about Gyakye-Quayson, Gyakye-Quayson. It's about all dual citizens. It is about, I estimate that about 5 to 10% of the population will be dual citizens. So that is approximately 1.5 to 3 million Ghanaians are dual citizens. And what the Supreme Court is telling the 3 million Ghanaians is that, one, they have no right to be represented in the parliament, for someone like them to have someone like them represent them in parliament. Two, they cannot have somebody to look like them and be in the executive. Three, they cannot have somebody like them be on the Supreme Court. Four, they cannot have somebody like them be a leader, a founding member, or even an executive member of a political party. So when you look at the diaspora branches, they have the NPP, UK, NDC, Japan, and so on. No dual citizen is supposed to be an executive member of those overseas branches. And the interesting thing to me is that the presiding judge, who is saying Ghanaians cannot be on the Supreme Court if they have the citizenship of another country, is himself a justice of the Supreme Court of Gambia. Now, his not being a Gambian has not stopped him from competently executing his functions as a Supreme Court judge of Gambia. So why does he come to Ghana and then forget that he himself sits on the Supreme Court of Gambia and somehow misinterprets allegiance to exclude Ghanaians from sitting on the Supreme Court? What is going on here? On the other hand, if you go to a country like Sierra Leone, and if you go to a country like Nigeria, their courts have said, look, in today's modern world, citizenship does not mean subject who owes allegiance. Citizenship means a person who has certain rights. And if you have allowed a person to be a citizen of another country, then that same law cannot deprive him of the basics of citizenship, which is the right to participate equally and fully in the political community. That to me is progressive jurisprudence. That to me is a broad reading of the Constitution, a reading of the Constitution that does not just try to understand allegiance, but also tries to understand what is modern citizen. What does it mean to say you are a citizen of Ghana. That has to mean something. If you say a citizen of Ghana is someone who cannot go to parliament, who cannot be on the executive, who cannot be on the judiciary, who cannot be on the constitutional body, what you have created is not a dual citizen. You have created a fractional citizen. It's almost like you are a 50% citizen. And if you want to be a full Ghanaian, then renounce your other citizenship. But that was never the intent of Parliament when they allowed dual citizenship. If they wanted to, when they allowed dual citizenship, they could have added Parliament to the offices that were excluded. They didn't. And if you read the Constitution, Article 8.2, it actually starts without prejudice to Article 94.2. That will tell everyone that Article 94.2 means something completely different from Article 8.2. To read the Constitution for Article 94.2 and Article 8.2 to mean the same means the person does not understand the simple canon of construction called principle of meaningful variation.
It would be interesting to read the full judgment of the Supreme Court. Certainly, that full judgment will give us some understanding of what really brought us where we are today. But Mr. Quayson, for some reason, believes that what was said on the 17th of May, 2023, flies in the face of many previously decided cases. Is this something that you agree with?
Absolutely. And let's be clear that Mr. Quayson's case is sui generis. It is very different from the Adamu Sankadi case.
Yeah.
Because in that Adamu Sankadi case, he had not actually renounced his citizenship, even when he was in Parliament. Mr. Quayson had renounced his citizenship even before the election. So you cannot compare the two. Secondly, our law is actually very clear that Article 99(7), which relates to whether or not a person is qualified to go to MP, is a matter that is reserved exclusively for the High Court with a final appeal to the Court of Appeal. The Supreme Court doesn't even have jurisdiction. Anybody who followed the then Woolensey case, in Woolensey, there was a question of whether the elected member hailed or resided in the constituency for the statutory window. And he lost at the High Court. He went to appeal and lost at appeal, and he attempted to go to the Supreme Court. The Supreme Court, in a 4-1 decision, which I remember very well, said that they had no jurisdiction. The Court of Appeal is the final stopping point. Now, let's be clear that the plaintiff here tried to be clever, because when he went to the Supreme Court, he did not say he's coming there for the resolution of an election dispute. He said he's coming there for the interpretation of Article 94(2)(a). So that's what the plaintiff said. But it was up to the Supreme Court to understand that this is the same election dispute disguised as a constitutional matter, and they should have declined jurisdiction. Shockingly, not only did they not decline jurisdiction, but right there, they imposed an injunction on the member. They injuncted him from going to Parliament. And so if you go back to the record, on that day when the injunction was imposed, I was on radio or TV, I think it was with you or one of the Joy people, and I advised him that if I were him, I will resign now and I'll go and run for the by-election, because a Supreme Court that is going to give you a fair hearing will not injunct you. The injunction is a clear message that they've already taken a position. And all the 15 months that have gone by, I mean, they don't even have an opinion for us, even though this thing has been pending for over 15 months. So that should tell you that, to me, this is not something that is very carefully considered, and the Supreme Court should do better than that. Especially, this is not about Gyakye-Quayson. This is about 3 million Ghanaians. Anytime a court is going to say 3 million citizens cannot go to parliament, or they can't, they don't have the right to go to parliament, they don't have the right to be on the executive, they don't have the right to do that, and they have that. They have to be very slow. They've done in Nigeria, as they've done in Sierra Leone, because citizenship matters can create all kinds of conflicts. Most people don't realize that the first civil war in Ivory Coast was triggered because Ouattara was being disqualified on grounds that his father comes from Burkina Faso. You go to Rwanda, the Hutus and the Tutsis. Even in the US, the civil war was fought because blacks were treated as less than full citizens. So anytime you are going to make a ruling that is going to say 3 million people are fractional citizens, every court would hasten slowly, especially in today's world where we all understand the importance of an inclusive community because we are members of the African Union, and where the Charter at Article 13 clearly says every citizen should have the right to participate equally and fully in the political space, something that is repeated at the UN, something that our Constitution, even in the preamble, says that we want to be equal citizens. Why would the court want to create social cleavages? Why would the court want to be exclusionary? That baffles me. Modern courts don't do that.
Now, there's a question, though, because of the conversation about what happened at the Supreme Court. If you recall, right from the beginning of the election petition, at the High Court in Cape Coast, there was an application for interim injunction, which was brought by the petitioner too. The lawyers for Gyakye-Quayson actually asked the judge then, Justice Boakye, to make a reference to the Supreme Court for interpretation of the provision in Article 94(2)A, which is what we've been talking about here. Now, Justice Boakye refused and insisted both in his ruling granting the order of interim injunction and in the final judgment too, that there was no issue of interpretation necessitating a reference to the Supreme Court. Now, it appears that those decisions of Justice Boakye in the High Court is somewhat at variance with what the Supreme Court is now saying, which indicates that there's an issue of constitutional interpretation which gave the Supreme Court the jurisdiction that it assumed in order to make the orders it did on the 17th of May 2023. Is it right to presume so?
Absolutely on point. Absolutely on point, because as you are indicating, the Gyakye-Quayson team tried on many occasions to get the matter moved to the Supreme Court for an interpretation. And not only was he denied by the High Court judge, he was also denied by the Court of Appeal. And in fact, he was also denied by the Supreme Court itself. Curiously, when the plaintiff went to the Supreme Court, all of a sudden they granted him jurisdiction. So there's almost at every point in the fight, there appears to be a situation where the court is more willing to hear from the plaintiff and less willing to hear from the defendant. And that's what I said earlier, that if I were him, once there was that injunction from the Supreme Court, which should never have happened, I would have advised myself, and I said, look, these guys are never going to give me a fair hearing, so I'm going to go back to my voters and then ask for them to vote me again, because now there are no questions about my allegiance whatsoever, and then we would have resolved this issue. But yes, it is problematic that Justice Boakye indicated that there's no interpretation issue here, and the Supreme Court, months after, indicated that there's an interpretation issue here. Both of them cannot be correct. Both of them cannot be correct. So if indeed there was an interpretation issue, then the proper thing was for the Supreme Court to vacate the orders of Justice Boakye and remand the case back to him to try it consistent with whatever definition they give on Article 94(2)A. But they went beyond that. They assumed the role of a high court, and then they actually wrote to the parliament to expunge his name from the from the road. I think, to me, we are at a point where we all have to ask ourselves a salient question. Do we want to run a country where about 10% of the population who are given the same duty to defend the Constitution? The Constitution says every Ghanaian has a duty to defend it. Okay. It doesn't say it's dual citizens, every Ghanaian. So if they have a duty to defend the Constitution, why can't they have the commensurate right to participate equally in the political community? And we have to then say, look, we want to be a progressive community, we want to be a progressive society, so it's time to repeal Article A2 and Article 94(2)A. Fortunately, there is bipartisanship on this matter.
Yeah.
The president says he supports it. Mm-hmm. The running mate or the ex-president Mahama says he supports it.
Very much so.
The Council of State has endorsed it. So it's a question of Parliament putting it to vote. And if we get the two-thirds of parliamentarians to vote for it, these issues would go away and we'll be only left with this ruling from the Supreme Court, which will go into the Judicial Hall of Shame along with Akoto and some other decisions. It's a very, very poor decision in my mind.
Now, let me ask you this question, because it's not 100% legal in its form. The question is about whether or not it is prudent for a man who is standing trial in a criminal court facing charges of perjury and other criminal offenses. In fact, 15 days from today, Mr. James Gyakye-Quayson will be going back to that particular court to face the same case of perjury and other criminal offenses that have been leveled against him connected to this particular matter, to seek, among other things, 2 weeks later, to be on the ballot and be voted for when his fate has not been determined in that particular criminal trial.
Look, in 1951, Prime Minister Kwame Nkrumah was in prison, and he was elected as an MP, not just as an MP, but his CPP won, and he became a prime minister. He was in prison, and the voters voted for him. The colonialists released him because the colonialists understand the importance of voting. The voice of the people is the voice of God. When the people of Asinov say, we want this guy, people should stand out. People should get out of their way and allow their voice to be heard. It's not up to the Supreme Court or the High Court or anybody to intimidate the voters and say, no, even though you want this guy, we are going to persecute him and prosecute him and so on. We are in a Republican, we are in a democracy. We claim to be liberal Democrats. What are we doing to ourselves? Quayson has not been convicted of any crime. He's been put on trial. I don't know for what. They say perjury. Perjury. Yes. Where has he lied? He was cleared by the Electoral Commission based on PNDC Law 284. Where is the lie? The forgery. What has he forged? They have taken the charges that were filed against Adamu Sankedi and replicated that without any understanding of the factual differences between the two situations. It is. I don't take that prosecution seriously. So he should run. And if the voters speak, then God has spoken. And he should go back to Parliament, and the injustice that has been done to him should be redressed.
Can he remain in Parliament? Because in Section 210 on perjury, for example, he can be going to jail for up to a decade, as we are being told. And perjury is rarely a second-degree felony.
Yes, but the question is, where is the perjury? I mean, anybody at all can put anybody on trial. Are we saying that 1 week or 2 weeks or 6 weeks to the election, if the Attorney General goes and say to the opposition member, I'm filing a charge of perjury against you, then the opposition, the NDC member, Mahama, should step down because some charges of perjury has been brought against him? That would be the surest way to kill democracy in this country, to allow an attorney general's office that is run by the executive to use his power of prosecution to intimidate people and to tell us who can run and who cannot run for parliament. That is not what we fought. I fought for this fourth republic as a student. That was not what we fought for. We didn't fight for a situation where the attorney general is using his power of prosecution to determine who can run and who cannot run for office.
Now, let me
as long as
yes, please conclude that point before I.
As long as he has not been convicted,
okay,
then he can run, and that's why I gave you the example of Kwame Nkrumah, who was in prison because of the riots, and yet he was released immediately. The people voted for him because they understood the power of the vote.
The point people have made is that, I mean, they are unsure whether or not he would be exonerated or he would actually be convicted. Because of that uncertainty around it, would it not be more prudent? That's why. It's a political question, not a question of law, really.
Well, you know, we live in we believe in the presumption of innocence.
Yeah.
He has to be presumed to be innocent, and he cannot abandon his life and his work and his love for his constituents merely because somebody has filed some charges against him, the factual basis which no serious person can appreciate. They say perjury. How did he commit perjury? He went to the EC and said to the EC, I've applied to renounce my citizenship. The EC said, okay, come and show me your certificate of renunciation. He went to the EC and showed the EC the certificate of renunciation. At the time that he was showing that certificate, the PNDC law 284 was very clear. You have to show it before you go to parliament. Now, subsequently, if the Supreme Court has interpreted the law to say that he had to show it when he was filing for the nomination, how do you then say that he should have anticipated what the Supreme Court was going to say and not do what he did?
Without producing the kind of criminal case that's already ongoing, some say the Supreme Court case really is a nail in his coffin.
In terms of what?
That it may have an impact on what the criminal case is supposed to be.
No, the criminal case is completely independent. The Supreme Court determined the meaning of Article 94(2)(a). The criminal assize or the criminal court is not trying to find out whether or not he violated Article 94(2)(a). No, they are trying to find out whether he committed perjury.
Okay.
Using maybe the same facts. Mm-hmm. But perjury has a very specific meaning under the law. It is not just stating something that proves to be false. It's stating something knowing that it is false. So if you didn't know at the time that you were making that statement that the statement that you were making was false, then there's no perjury, even if it happened to be false. And this guy, not only did he not know that what he was making, the statement he was making was false, but even the Electoral Commission, who is the regulator of elections, did not think the statement that he made was false. So how come some court is now coming in to say the Electoral Commissioner did not know his job, and because the Electoral Commissioner did not know and do his job, this person should be held criminally liable for perjury? If we apply the law that way, 95% of us will be in prison.
Prof, I'm grateful to you this evening, and unfortunately I've run out of time, so we should be able to pick up and continue our conversation on that particular level, maybe in the future, but I'm grateful to you, sir. And
thank you, Raymond. It's a pleasure to... Hope you enjoyed your visit to the US. I saw all those clips that you were sending.
Okay.
And so thanks for having me again, and always a pleasure to be with you.
I am grateful to you. Professor Stephen Gyakye-Quayson is a man who is an activist and lawyer and also a distinguished public intellectual of higher standing. That's where we end today's edition of UPfront. Many thanks to you for joining us.
We have seen a lot together, and through it all, the faces here at Joy News have looked you straight in the eyes and asked the questions you've always wanted to ask. We've been fearless but compassionate. We've been relentless with our probe. We have given you the microphones.
The boy they killed is my best friend.
We here at Joy News are always honored to share each day with you. My name is Ernest Minu, and this is Joy News. Credible, fearless, and independent.
Boxing is Ghana's most successful sport at the Olympic Games. Based on this inspiration, the young generation are also projecting for big honors.
I promise you Ghana for a gold medal.
You need the EcoBank salary account, bro. See, with the EcoBank salary account, you will enjoy free life insurance, free debit card, save while you spend, and an amazing chance to double your salary, and even more consolation rewards in the EcoBank double salary promo reloaded.
Guy, this EcoBank salary account sounds interesting. What do you think?
Man, see the white sign it here.
Open an EcoBank salary account today for a lifetime of benefits. You also stand a chance to win more than double your salary in the EcoBank Double Salary Promo Reloaded from now till July 31st. Terms and conditions apply.
And the job life regardless.